Hi, it's Bernard Nomberg with the Nomberg Law Firm, back for another week on our Tuesday morning videos talking about some area of the law that the Nomberg Law Firm and the attorneys here that we handle. And today we are talking about what a trial is like in a workers' compensation case. And we appreciate anybody, all of you who call in, write in, or watch these videos. It's our way of just trying to share a little bit of the law with you and explain some things that you may have questions wise, and show that it's not as scary as it may seem. It may hopefully take a little bit of the stress away. Again, I'm Bernard Nomberg with the Nomberg Law Firm, downtown Birmingham. David and I handle workers' compensation matters and Social Security disability as well as personal injury claims. And in the past couple of months, each week we've been sharing with you various topics on the law, and you certainly can find those on our Facebook page as well as on our Nomberg Law Firm website. So today we're going to talk about what it's like to go to trial in a workers' comp case. I'll first state that most workers' compensation claims don't reach the trial phase. It's the very nature of workers' comp in Alabama that we can usually resolve the claims for what the client is hoping for in the matter without having to get to that phase. I think Alabama may be unique in that we may be the only state that still has a trial as part of the workers' compensation system. Most states, if not all other states, do it administrative, largely submitting paperwork, and it's viewed by a council or a committee that makes decisions. But most of our cases can be resolved without even having to file a lawsuit. But some of those small percentage have to be filed as a lawsuit because you just can't work out whatever the issues may be. And you need a judge, not a jury, but a judge to help us find our answers, to get to the bottom of the disagreement between the parties. And like I said, these are judge-only cases in Alabama, the trials, that is. There's no jury in a workers' comp case. And they usually, after you file your lawsuit, you conduct what is known as discovery, and that's the exchange of answers and documents. And typically our client will have to be deposed under oath. Sometimes we take the depositions of corporate representatives or witnesses. It depends on how it depends on how complicated the matter is, how contested the matter is. As I've said many times in these videos, every case is fact specific. I'm just giving a general overview about how things go. Usually you might have to file a lawsuit because the employer or the insurance carrier is contesting the compensability. They're denying that the workers' comp claim should be going forward, that either the accident didn't happen at work, like the injured worker says that he or she said that it did. The injuries that are being complained about, they're denying that happened at work, or that the causation of the injuries didn't come from anything having to do with a work accident or incident or repetitive actions. So you have to file your lawsuit, and we get either one of two things typically happen by way of a trial, depending on what track we're on, which is determining whatever the issues may be between the parties. And for example, if we have a denied claim, let's say that someone is claiming they hurt their back on a construction site, and the employer or the insurance company says, no, we know you had a bad back beforehand, or we understand you had a car accident completely unrelated to work, so we're going to deny your claims. You're now going to have to file your lawsuit, which you do, and you proceed to the first, we'll call it a mini trial or a compensability hearing. And that's not a full-blown trial on all of the merits of the case. You're just asking the judge to be the arbiter to determine whether or not we have a compensable claim. And that typically is more often than not the type of a trial that we have. and it comes fairly early in the process after you filed your lawsuit and gone through discovery. It's asking the court to analyze the evidence up to this point, the medical records, the testimony that may be being put forth, to determine whether or not we have a claim that can go forward to a final trial. The final trial is when the judge determines the degree of disability, etc. But in the compensability phase, the earlier mini trial, we're putting on evidence in front of the judge explaining how the accident occurred, how the injuries developed from the accident or the event. The other side, of course, gets to counter with their defense of the case, claiming that the accident didn't occur at work or it didn't happen at all. There may be a few witnesses. These trials typically take less than a half a day, sometimes just a few hours, and oftentimes it may only be the injured worker who's brought the action, maybe the only person who testifies. Usually, if the two parties, the attorneys on both sides, are getting along, which in our cases, most of our cases, we prefer it that way, we'll both agree to submit to the court the pertinent medical records and any other documents for the judge to consider. After the client puts on the testimony, there may or may not be any other witnesses. Those witnesses could be co-workers or a spouse or someone who witnessed the event. The other side also gets to put on their side of the trial, which it could be that they do nothing. They could just rest, or they may put on witnesses to counter what our client had to say occurred at work, or how the accident or injuries came forth. After that, the judge will ask typically for both sides to submit a written order for their arguing their sides, and then the judge will issue an order on the compensability. And if compensability is determined to be in the favor of the injured worker, then we move to the next part of the case, which is usually going to be the degree of disability. If the judge, on the other hand, rules against our client, that typically effectively ends the lawsuit and the litigation in the case, because that's the judge's way of saying, I don't think there's enough evidence here to show that there is a compensable claim to go forward. But in the event that we are successful on the first go-around, the compensability hearing, the timing of the next or the final trial will largely be determined upon the timetable or the calendar of how long it takes for the injured worker to reach maximum medical improvement and be rated, and for in certain circumstances, for the employer to make a determination if the injured worker is eligible to go back to work. And the second or the final trial, that usually is a lot more involved. In certain circumstances, there can be expert witnesses, doctors' depositions, which could be also used in the compensability case, but usually it's not going to be there. Usually the medical records suffice. But in the trial at the end of the case, doctors rarely will be live in the courtroom. Usually we'll have taken their depositions and could submit those depositions to the judge to analyze when he takes the case under submission after the trial. Again, at the end of that case, then the judge will ask again for orders from both sides, and then hopefully issue an order shortly after that. Well before either the compensability trial or the final trial, we'll meet with our clients, we'll go over all the issues, and we'll try to prepare them well ahead of time. We'd like to go by the courthouse if it's convenient before the trial to show them the courtroom, show them where they'll be that day, where to park. Just try to make them feel more comfortable, because we don't want to ever just take for granted that it's something that we do all the time and have for many, many years. It may be the very first time our clients have ever been to the courthouse. These cases can be stressful. These trials can be a stressful time in their life. We try to take out some of the worry. We try to take out some of the unknown. Try to answer as many questions that we can. Again, many many percentage of the time, or most of the time, we never even have to file a lawsuit to get a case resolved. But there are those few percentages cases that we do have to file a lawsuit, and then we have to proceed to a compensability hearing, and then maybe even to a final trial. If you ever find yourself in these scenarios or these situations and needing of legal advice, please give us a call at the Nomberg Law Firm. We can be reached at 205-930-6900. Of course, we're on all sorts of social media, nomberglawfirm.com. We'll be glad to answer any questions. Please feel free to email us or just reach out to us in any way that you can. We appreciate you spending a few minutes with us again on another Tuesday morning. We're going to have another topic next Tuesday and hopefully answer any questions that folks have. We hope you have a good rest of your day. Take care.